Good evening, everyone, and thank you for joining us. Excuse me. Today is February 20th, 2014. My name is Frank Buquicchio, and I'm a partner at Vincent Rousseau & Associates, and I'll be hosting tonight's webinar, which is entitled How to Qualify for Medicaid and Protect Your Assets. Before I begin, I have a couple of administrative items, but before I even get to those, I want to first apologize if anybody this webinar was supposed to be presented last night, and we had there were problems with the program, the GoToWebinar program. So Melanie and I tried to work on it for a good 25 minutes, trying to actually get the broadcast going. So I know we had a number of people online, and it was probably very frustrating because you couldn't see anything and you were waiting around, and we couldn't even message you. So we apologize for that, but we contacted the company, and apparently it was a problem with their program. So obviously it's been fixed. So we're glad you're here tonight. Excuse me. I just want to let you know that the presentation will last approximately 1 hour, and during this time you'll probably have some questions. If you do, you can type your questions at any time using the question pod, which is located in the lower right-hand corner of your screen, hopefully. We'll try to address these questions as we go along, but I'll also leave some time at the end for Q&A. No question is unimportant, and I'll answer as many questions as we can during the time frame. Please note also that we'll be discussing financial and legal matters, and that this program is not meant to be a substitute for obtaining professional, financial, and legal counsel. There's your disclaimer. Excuse me. At the end of the presentation, you'll see our contact information, so please feel free to contact us with any questions related to tonight's material or any other questions that you have that we may be able to help you with. And finally, after the presentation is over, you're going to see a survey. Please take a minute or two to answer those survey questions. We do read the surveys, and your feedback will help us to develop and improve on our future webinars. So thanks again for joining us, and we're going to get started on this presentation. So first, just kind of an overview of what I'll be covering tonight. We're going to talk about how to access quality long-term care. We're going to talk, and probably just as importantly, is how that gets paid for. We're going to talk about who has the right to make decisions for you, healthcare decisions, financial decisions, and the like. And then we're going to also talk about what happens if you don't have a plan, which is, it's not going to be a great conversation, but I think it's something that everyone needs to be aware of, and hopefully they will take the appropriate action and implement at least a basic plan to make sure that things are taken care of in a proper way if something was to happen. So long-term care planning, just some typical scenarios. These are just fictional people, but typical scenarios that we hear as elder law and special needs planning attorneys. We hear these on a regular basis. So Mary's mom has Alzheimer's and is not sure if she can take care of herself. Janet is having trouble living on her own. Sam needs nursing home care, and he may or may not be married. We'll talk about those different scenarios in a little bit. Harry's worried about losing his house if he gets sick, and William is considering purchasing long-term care insurance. So, in terms of planning, these are some typical common situations that if you haven't heard about or been part of, you may know somebody who's had a similar situation. And we'll kind of walk through what needs to be done in each of these. So paying for long-term care, big concern for a lot of people, especially as we get older. You can see the woman there is very pensive and thinking about these things. So how do you access quality care? Who's going to provide the care? And how will the long-term care be paid for? So accessing care and providing the care, that's usually done through either insurance, through Medicaid, or through private pay. That's it. You're not going to get Medicare supplemental insurance to cover long-term care. Those are meant to be short-term solutions. So anybody who's been through this or has a family member who's been through this knows that in the typical scenario, some event happens and you end up in the hospital, and then you go for rehabilitation. And if you have Medicare and a Medicare supplemental insurance or a Medigap policy, or maybe an HMO, then there's some coverage, but it's only up to a point. With Medicare, it's up to 100 days, and then after the 100 days, well, let me go back a minute. there's no guarantee that you get the 100 days. A lot of people think that because I'm entitled to 100 days that's an automatic, and that's not the way it works. Medicare will pay as long as there's a skilled need. Excuse me. So if you're in rehabilitation and going for rehabilitation, then Medicare will pay for that care. The first 20 days, Medicare covers 100%, and then after that, from day 21 up to 100, there's a copay that may or may not be covered with your supplemental, and that's something you can look into with your supplemental carrier. But the Medicare coverage could be 28 days, it could be 37 days, it could be 56 days. It's some period of time up to 100 days. Once you get to that point where Medicare is no longer covering, whether it's because your rehab has plateaued, is the term of art that's used, or because your insurance coverage has run out, now the question is, do I need to stay in a long-term facility, or am I going to come home? And in either of those scenarios, if I need care, how's it getting paid for? So now we're going to look to one of these other three. Do you have long-term care insurance? And if you do, great. When we look at that and see if that covers it, you can private pay out of pocket, and sometimes people are forced to do that if they haven't done advanced planning. And then, of course, we're going to talk tonight about the Medicaid program. But the Medicaid program has very strict financial eligibility rules that we'd have to go through. So let's first talk about long-term care insurance. We're huge proponents of long-term care insurance in the right situation. You can get coverage for care at home. So if you have an aide or nurse coming in, a personal needs assistant. If you have assisted living, generally, depending on the policy, but generally long-term care insurance will cover assisted living as well. And then, of course, nursing home care. The issues that we find in terms of long-term care insurance are, number one is, can you afford it? And you know, unfortunately, the older we get, the more costly it becomes because the greater chance you're going to need care. So long-term care insurance can be costly, but it's something to look at. Are you insurable? And that's not a decision we make when we're talking about clients and we recognize that maybe they should be looking into long-term care insurance. Then we'll recommend, if they'd like, a couple of long-term care insurance agents who are competent and can talk to them about those types of things, insurability and the cost. But in certain circumstances, it's the right recommendation. It's something to look into. Somebody who's insurable and can afford it should be looking at long-term care insurance. But it's not for everybody. So for those who either excuse me, can't afford the insurance or not insurable, or they're insurable, but because of certain health issues, it raises the premiums to an unaffordability standpoint, then we're going to potentially look to Medicaid. But as I said, Medicaid, because it's a government program, it's not an entitlement program like Medicare. It has very strict financial eligibility rules. Excuse me again. But if approved, you can get coverage for home care, you can get coverage for nursing home care, and then in some limited circumstances, there are a few assisted living facilities that accept Medicaid as well. I want to say there are probably, I know there are three, two in Suffolk, two in Nassau for sure, and I think there was another facility in Nassau that was being built. I'm not sure if it's up yet. But there's some limited coverage on the assisted living side. Generally speaking, assisted living is private pay. So again, very strict eligibility rules for home care and nursing home care coverage, which we're going to get into in a second. When we talk about the financial eligibility rules, there are asset rules and income rules, and if you're married or single is also going to factor in. If you're married and you're applying for one spouse, Medicaid actually has rules as to both of you. So even though only one spouse is applying, Medicaid has rules as to how much both of you are allowed to keep in terms of assets and how much each of you, I should say, are allowed to keep in terms of monthly income. And that's something that we would help you go through and work through and understand how we can qualify you for Medicaid in the appropriate situation. The general rule with Medicaid is, and you may have heard about this 5-year look back, excuse me, is that If you give away assets, Medicaid has a problem with that if you're applying for nursing home care. There are exceptions to the rules, like all rules, I guess, and I'm going to go through a couple of the bigger ones. One huge exception is that there is no look back for Medicaid at home, which is sometimes referred to as community Medicaid. So if you're applying for help at home for Medicaid, there is no look back. So as far as the transfer of assets, there's no issue there in terms of getting assets out of your name. Now, we want to be careful as to how you do that, because there are smart ways to do that, maybe not so smart ways to do that. So if there are assets that need to be transferred, we want to make sure that it's done smartly. But it's very important to note that for Medicaid home care, there is no look back. So if somebody needs help at home, I actually had a conversation with someone a couple of weeks ago who had called me because they had said, well, we had taken some money out of mom's name, and it's almost 5 years now, so we can almost apply for Medicaid. She's at home, and we can get her some help at home. And I explained to them that they didn't have to wait, that they could have gotten it whenever she needed the help, because there's no look back. But for Medicaid nursing home care, there's a 5-year look back, and we're going to talk about some planning techniques in terms of how we can protect assets, whether it be in crisis, which we're going to talk about now, or more importantly, advanced planning. Medicaid planning in crisis is something that we can do for clients, but it's not something that I would suggest that you want to wait around for in planning. Advanced planning is almost always better for a number of reasons. Number one is probably stress, because when you're in crisis, you're having to think about other things as opposed to, all right, well, now what do I have to do in terms of protecting my assets? But I think one of the most important tips I can give, I guess, or pieces of information, or nuggets, as we like to say sometimes, in terms of planning a crisis is there's no reason that anybody should ever lose all of their assets. Even if nothing has been done in terms of planning, there's almost always something we can do to protect some of the assets. Now, again, remember with Medicaid home care, there is no look back, so that that we can usually protect all of the assets in that situation. But I just want to tell you a quick story. A couple of years, well, actually a number of years ago now, I met with a woman. It was about her mom, excuse me, and her mom was in a nursing home. And the reason that she had come in to see me was because the nursing home had suggested that she go see a lawyer about applying for Medicaid because her mom was almost out of money. And her mom, I think at the time that she came to see me, the mom had about $30,000 in the bank. So mom had $30,000 in the bank. The numbers today for Medicaid purposes, you can't have more than about 14. Back then, I think it was like 3,000 or 4,000. This is years ago. And I found out that the mom had been in the nursing home for over 2 years. So she had no long-term care insurance, and we know that Medicare doesn't cover nursing home care for 2 years. So if she's got $30,000, obviously she doesn't have Medicaid. So what happened over those 2+ years was that the daughter had spent she had over $300,000 when she went into the nursing home, had been paying the nursing home privately, and was unaware, because she thought it was too late, was unaware that there were things that she could have done to save some of that money. And the general rule is about 40 or 50%, depending on how the numbers play out. She was unaware that she could do anything. She thought she was just going to have to spend that money down. And because the money was almost out, the nursing home sent her to us to talk about the Medicaid application. So I explained to her, as I'm explaining to you, that if she had come in the beginning, that we would have been able to save a nice amount of money for her and her family, as opposed to having it spent down, even though it was last minute. But again, that's crisis planning. So again, the takeaway is you shouldn't ever lose all of your assets. So even if you're in crisis, don't assume that it's too late. Contact us. Let us talk about what we can do to help and preserve as much as you can. Some of that is going to involve potentially spousal allowances and or what we call exempt transfers. And again, I'm talking nursing home care because for the Medicaid home care there is no look back. So conceptually it's just kind of get rid of the money. But when we're talking about nursing home care and their look back period of 5 years currently, can we still do things kind of at the last minute to preserve some assets? And the answer is yes. If there's a spouse, there are certain spousal allowances and transfers that can be made between spouses that Medicaid is okay with, and there is no penalty or waiting period. There are also a handful of other exceptions other than spousal that you can transfer assets, your home for example, or liquid assets to certain people, and even if it's done at the last minute, it's considered to be what's called an exempt transfer, and Medicaid will not assess a penalty. So the key is to know that there are exceptions out there, and if you're in crisis and planning hasn't been implemented prior to the crisis, that you see somebody such as ourselves who knows about these different exemptions, so that if you fit into one of the exceptions, we can do some nice things to protect assets and make sure that the care is appropriate and is provided. Okay, so I like planning in advance personally because it's a lot less stressful. So one of the most common planning techniques when people are planning in advance, meaning they're not in crisis, is what we call a Medicaid Asset Protection Trust. This trust, it's a form of irrevocable living trust, and it can be funded with your residence. It can be funded with other liquid assets. And once you put the assets into this trust, the trade-off is you have to stay out of a nursing home, or you and your spouse, if you're married, have to stay out of a nursing home for 5 years from the funding of the trust. So if you set up a Medicaid Asset Protection Trust in February of 2014 and you put your home into it, and you get to March of 2019, which is more than 5 years later, and you have to go into a nursing home, whatever's in that trust is protected. If your home is in the trust, it's protected because you've made it past the 5 years without needing nursing home care. So it's a wonderful way and very effective way to protect assets in advance from a nursing home in a long-term care situation. Excuse me. A couple of things on the Medicaid Asset Protection Trust. As I mentioned, number one is it's irrevocable. But there are a couple of nice little, what I call strings attached to the trust, because I think some of this for some people is about control, to some extent at least. So, for example, I put my home into my trust, and, Frank, well, if my home is in this irrevocable trust, what if I want to sell it? Can I sell my house? And the answer is yes. But the trustee, the person who's managing your trust, is the one who would have to sign off on selling the house. Well, you're going to control, this first string is you're going to control who the trustee or trustees are. So if you name your child, for example, as the trustee, and you decide you want to sell your house one day, and that trustee decides that they don't want to play nice and they're not going to help you sell your house, you're going to have the right to fire that trustee and put a new trustee in. And that person will do your bidding, hopefully. Otherwise, they'll get fired and you'll put somebody else in. The second string is there's a special provision that we can put in the trust that allows you to ultimately change who the beneficiaries of the trust are. So that kid who you fired as the trustee, if you're really ticked off at them, you might want to change them as not being a beneficiary, maybe not getting as much as they were going to get. So from a control standpoint, there's not a couple of nice little strings to it. From a protection standpoint, it's fantastic, not only for you, but also for your family. The way to protect assets, assuming you don't have the long-term care insurance, for example, is to get them out of your name. And there are smart ways to do that and not so smart ways to do that. Putting assets into your children's names generally is not the smart way to do it. Not that there's anything wrong in particular with any one or more of the kids, or if there are, obviously then that's a concern, but even the best of kids, I mean, things happen. We're human beings. We get sick, we get sued, we die, we get divorced. Trusts don't have any of those problems. So if you've got your home in your kids' names, for example, and God forbid something happens with one or more of your children, that becomes everybody's problem now. If the home is in an asset protection trust, and God forbid something happens to one of your children, no problem. It's in a trust. It's not in their name. The trust is its own entity. So it's really a terrific way of protecting assets. And certainly if anybody has got any questions, I would encourage you to ask us about more about the trust. Excuse me. Now we've got our basic, what I call basic, but I don't mean to minimize their importance, the must-have legal documents. So we've got a durable power of attorney, healthcare proxy, a living will, and then a last will and testament and/or a living trust, depending on what your plan is going to be. So the power of attorney is for financial matters, so you can appoint an agent, someone to act on your behalf if you were to become incapacitated. So that person can step in and handle your financial affairs for you, including Medicaid and asset protection planning. The healthcare proxy is for healthcare decision making. So again, you become incapacitated, you can appoint who you want to step in and make health decisions for you, any health decision at all. The living will, which deals specifically with end-of-life decision making. So, for example, pulling the plug, excuse my bluntness, but that's how a lot of people understand it to be. So you can state your wishes there in terms of life-sustaining treatment or not. And then, of course, when we pass away, we have a will that says, as I say, who gets it, how they get it, and when they get it. So power of attorney, healthcare proxy, living will, those documents are for us while we're alive. We pass away, those documents are no good anymore. They're only lifetime documents. And then your will or your trust or your whatever else in terms of planning you have would take over at that point. So everybody over 18 should have at least these four things: a power of attorney, a proxy, a living will. I guess the living will I'll say is optional depending on how you feel about end-of-life decision making, and then some kind of last will and testament. The will is going to be, the terms of the will are going to be determined by a particular situation. There's no cookie cutter here. So, depending on if you're married or not married, your age to some extent, children, no children, does anybody in the family have any special needs? If you're older, you're concerned that, well, if my spouse ends up in a nursing home, I want to make sure they're protected. So there are different provisions that can be put into your will so that your will is designed to meet your specific needs. So if you're, as I said, if you have somebody who has special needs, we can put special language into the will to protect that person if they were to inherit from you. Okay, so very important to have these documents. Okay, so a little bit of detail on the power of attorney. As I mentioned, it's for financial decision making and management of assets. So basically, the way I like to say it is anything that might require your signature. That's what the power of attorney is for. You can basically give somebody the power to sign your name for you as it relates to any of the items as you see on the screen there. From a healthcare decision-making standpoint, of course, we have the healthcare proxy, but the healthcare proxy does not take effect unless you can't make your own decisions. So as long as you're able to make your own decisions, it's your decision to make. If you can't, now your healthcare proxy, your agent is going to step in and make any healthcare decision for you that needs to be made. Always, if possible, always have successor agents. That's true for the power of attorney as well. So name a primary person and then have at least one successor person if you can. If you can have more, then that's great. The healthcare proxy also has provisions about organ donation if you're so inclined, and you can also put information in there about artificial nutrition and hydration, but that's also that's more geared to really towards the living will if you're going to have a living will. All right, and that's this life-sustaining treatment. So again, you have the right to make decisions as long as you're capable of it, and if you can't, then the living will can instruct the medical providers as to what you would or would not want in terms of life-sustaining treatment, okay? Keeping maximum pain relief is typical of the living will. So, for example, I have a living will because my feeling is that if I am brain dead, for example, and there's no reasonable hope that I'm going to get better, then I personally don't want machines keeping me alive. Just keep me comfortable, and that's that. Okay, so that's basically what the living will says. What if you don't have a plan? Then we're going to, unfortunately, we're going to end up in court most likely, because if you haven't appointed somebody to make decisions for you, whether it be by power of attorney or healthcare proxy, then there is nobody that can do that for you, in particular the power of attorney. And what's going to happen there is we're going to have to go into court and ask a judge to appoint a guardian for you. The main issue there is that you have no control or say over who that person is going to be, number one. Number two is it's potentially a lengthy process. It'll take probably a few months, and it's going to cost a good amount of money. It's a court proceeding, so there are documents that have to be filed with the court. There are hearings, and all of that costs time and money. And now you've got a judge appointing somebody, as I said, who you may have actually never met before. I mean, it might be a family member, but there's no guarantee that it will be. And now that person has to ask court permission generally when they want to do things, including Medicaid planning or asset protection planning. So it's not something that you want to end up in. But if we have the situation where the person didn't have the documents, then the flip side of that is, the positive is that we can go into court and get a guardian appointed and ask for permission to do asset protection planning. So it's a proceeding that's available, but it's not something that I would want to, again, rely on. I'd much rather have a power of attorney and a healthcare proxy where I'm appointing somebody that of my choosing, that I trust to make decisions for me. Okay, last will and testament, of course, this is what I was saying before. You control who handles your estate or who manages your estate. That's going to be, of course, the executor. You control who inherits your assets and when. And then, of course, you can provide for family and loved ones in a protective way. So, again, there can be provisions in the will. So if you have a particular situation with somebody in the family that you want to leave assets to, that it can be done in a way that, for example, if they're getting government benefits such as SSI and Medicaid, that they don't lose their benefits. Or if they have other issues personally, that you can leave them their assets protected from whatever issues they have going on. All right, so very flexible, and it can be tailored to your needs. Okay, before I get into the living trust piece, hopefully Melanie is online with us, and I just want to see if any questions now, because I can't see from my side, unfortunately.
No, I have no questions yet.
Okay, thanks. So just a reminder, if anybody's got any questions, you can go ahead and type them into that the pod that I believe is on the right-hand side of your screen, and we'll check again in a few minutes. So, all right, living trust. Lots of different types of living trusts. All living trusts avoid probate. What is probate? Probate basically is going to court. When do you have to go to court? You have to go to court when the person who died owns something, some asset, in their name alone with no beneficiary. So if you have that situation, the person passes away, you go into court. If they have a will, it's probate. If they don't have a will, it's called an administration, but either way you go into court. If the person who passed away, if, for example, in the typical husband and wife situation, let's say they own everything together, when the first one passes away, then probably no need for probate because everything is owned together, or you have each other as beneficiary of the life insurance or your IRA account. It's going to pass automatically to the survivor. So if you're concerned about probate, then one of the ways to avoid probate is to set up a living trust. It can be revocable, it can be irrevocable, but the revocable trust, I'm saying revocable, not irrevocable, revocable trusts avoid probate but do not protect assets. That's very, very important because I've had, unfortunately, over the years, 20 years or so of doing this, I've had to undo a number of revocable trusts because the clients were under the impression that the revocable trust was protecting their assets, and unfortunately that's not the case. So if your goal is to avoid probate, then we can talk about a revocable trust. If you're not concerned about asset protection, that's one of the first questions that we ask when somebody comes in, whether it be a new client or even an existing client who's coming back. It's kind of, what are you looking to accomplish? What are your goals? What are your concerns? And if one of them is avoiding probate, then a revocable trust might be a discussion we have. If they're talking about, well, I want to protect assets, then we can talk about the Medicaid Asset Protection Trust, for example, that we talked about a little bit before. But that's a form of irrevocable trust. And then there are trusts to reduce estate taxes. So if the client has some assets and some wealth, then we can talk about setting up credit shelter trusts, and that can be done either through wills or through revocable living trusts. And then what I call the alphabet soup of trusts, where GRATs and CUPRTs and ILITs and things like that. Those are different types of trusts where you can fund those trusts with typically with liquid assets. The CUPRT is for residents, and after a period of time, those assets are no longer part of your estate for estate tax purposes. So if somebody has what's considered to be what we call a taxable estate, then we can talk about different living trusts to reduce and sometimes even eliminate estate taxes. So how do you protect yourself and your family? Obviously, the four must-haves, those 4 legal documents that I mentioned before, hugely important. In fact, when I talk about the power of attorney in particular, I usually refer to it as being gold. I can't stress to you enough how important and valuable a healthcare proxy and a power of attorney, and in particular the power of attorney, are to have. I would urge you, if you don't have them, call us, get them done. It will be a potential lifesaver later on if you ever need it. So hopefully not, but so we have the power of attorney, the healthcare proxy, the living will, and the will. You should also have a plan as to how you're going to pay for long-term care. I think, I may get this wrong, but I'm going to be close. The statistic was, and I think it was research that was done by John Hancock, that 50% of us who reach age 65 will need some long-term care in the future. So 1 out of 2 people who are age 65 or older will need some kind of long-term care. It could be in a facility, it could be at home, but 1 out of 2 of us, that's a lot. So chances are, if we're around long enough, we're going to need some level of care. So make sure you've got a plan as to how that's going to be taken care of if and when it happens. And then if appropriate, again, depending on the size of your estate, we can talk about a plan to minimize or even eliminate estate taxes. Just so you know, for the federal government for this year, the estate tax threshold is over $5 million. It's $5,350,000, I think is the number. So if you're under that and you pass away in 2014, then you won't owe any money to the IRS. In New York, however, the number is only, quote unquote, $1 million. So if you're over $1 million in New York and die, then you could owe some money to New York State, even though you don't owe any money to the IRS. So those are things that we would talk about with you as well. Okay, Q&A. Mel?
Yeah, I have one question here.
Okay.
Can you transfer qualified funds into a trust from a last will and testament? Is this a taxable event?
Excellent question. I'm going to answer what I think you're asking, and if I don't, then please clarify. So the short answer is a qualified plan. So qualified plan, we're talking about IRAs, 401ks, and the like, 403bs, retirement accounts, basically. Those cannot be transferred without first withdrawing the money, and that's the key. So if you're looking to put retirement accounts or qualified accounts into a trust, for example, the only way to do that now is to withdraw the money, and depending on your age, you might have to pay a penalty, but you'll certainly have to pay tax because that money has not been taxed. You can, however, name a trust as a beneficiary of that money, but that's talking about, of course, when you pass away. So again, going back to what I was saying before, which is, if that person was sitting in front of me and I said, well, what's your concern? And they said, well, I want to protect my retirement account. Then my response would be, well, for who or from whom? So if you're concerned about, for example, a nursing home, then generally speaking, I don't recommend doing advanced planning with retirement type accounts because, as I said, the only way to protect it is to take it out of your name. And if you take it out of your name, you're drawing the money out and paying tax on it. But Medicaid, if we're talking about Medicaid, has some special rules when it comes to retirement accounts. So generally don't deal with those until we're put in a position where we have to. So hopefully I answered that question. Any others now?
I do. How long does it take to apply for home care Medicaid?
The Medicaid process for home care is going to vary county by county throughout the state because it's you apply in the county where you live. I would say in Nassau and Suffolk County, from the time that you actually file the application, excuse me, assuming you have all of the information, you're probably looking at a month or two. It could be longer depending on how backed up the county is. And it could also be a little bit longer depending on how long it takes you to get all the information together to actually file the application. So if somebody came in today and said, you know, they hired our law firm to prepare and file a home care application, it usually takes a good, you know, couple of weeks to gather the information that needs to be submitted. And then once we submit, like I said, it probably takes a good month or two depending on the county and any backlogs to actually get a decision. I guess unfortunate part of that is, as generally speaking, you know, you're going to have to, if you need care during that time, you're going to have to pay for it because most agencies are not going to want to wait, you know, a couple of months to get paid. But if you use a Medicaid qualified agency, even if you lay the money out, if you're approved, there's a potential to get reimbursed a percentage on the dollar. It's not a full reimbursement, but there's a potential to get some reimbursement retroactively up to 3 months. The Medicaid nursing home application could take a year. But the good news there is that if you're applying for Medicaid in the nursing home, the nursing homes will wait and have to wait until the Medicaid decision. So it's not, you don't have to lay out the, you know, $12,000, $15,000, $16,000 a month for nursing home care because that's what it costs.
Okay, I have another question.
Great.
Can you briefly comment on the impact of non-qualified annuities on Medicaid planning?
Let me start by saying I hate annuities. And I only hate them from a planning standpoint. I know that they can be good investments, and I'm not an investment person, so I'm going to, you know, couch what I say. But so from a non-qualified annuity, the Medicaid has special rules for annuities, and this is going back to February of 2006, which was part of what was the Deficit Reduction Act of 2005. It was actually signed February 8th, 2006. And they changed the treatment of annuities with that new, well, it's not new anymore. I guess it's 8 years ago already. Time is flying. People are worried about 5 years, and, you know, 8 years is just coming by. So with annuities, if you can transfer an annuity from person to person, and unlike the retirement account, but there are a couple of things. One is that any income, any deferred income that's in the annuity will likely be taxable to you at that point. So if you, for example, have, you know, $50,000 as your initial investment, and you got a nice return on annuities because most annuities have a nice interest rate, and let's say you've gotten, you know, that 50 has become 60, and you transfer ownership of that annuity into a Medicaid Asset Protection Trust, I'm almost certain that you're going to get a 1099 from the annuity company saying that even though you didn't get the money, that you earned $10,000, and you're going to have to, you know, report that money on your tax return. I personally don't agree with that standpoint because of the way the trust is structured, but that's something you'd have to work out with the annuity company. But it's something that can be done. You can transfer ownership of a non-qualified annuity. The Medicaid issue there is that, and I have a client who we're doing this right now for, it's a husband and wife. The wife, who's the one who's in the nursing home, has had an annuity. The annuity was transferred to, is not qualified, it was transferred to her husband because that's an exempt transfer for Medicaid nursing home purposes, or for all Medicaid purposes. But because she did that under the current Medicaid law, the beneficiary of the annuity, she was the annuitant, which is like the insured on the life insurance policy. So when she passes away, her husband is the beneficiary, and she had her children as the contingent beneficiaries. Well, because we were applying for Medicaid under the Medicaid, the DRA, the Medicaid law, we had to make the state the contingent beneficiary. So the husband can be the first beneficiary, but we had to put the state, for Medicaid purposes, as this contingent beneficiary. So, and then the kids can be the tertiary or third beneficiaries. So if she passes away, if the husband predeceases her, for example, and she passes away, then Medicaid is going to get paid back either up to the amount of the annuity or up to the amount that they have laid out, whichever is less. So there are some issues with annuities, which is why I was saying that I don't like them, but it's something we can deal with.
Okay, I have another question.
Great.
Is there a difference between an immediate or deferred annuity? Does it matter if you start the annuitization? Sorry if I said that wrong.
Yeah, sorry. Tomato. Yeah, you can. Well, again, tricky because it's because of the Deficit Reduction Act. The deal with the annuity under the Deficit Reduction Act is basically if you do anything with it after 2006, that you're going to fall under this rule. Even if you bought the annuity 10 years ago or 15 years ago, and let's say you annuitize it, then annuitize it, for those who don't know what that means, basically means that you're converting it, usually irrevocably, you're converting it from an asset basically to an income stream. So the annuity company will, based upon your age and interest and the value of the annuity, will say, okay, we'll pay you X amount of dollars for either a certain period of time or for your lifetime. And once you do that, that payment now becomes income, and it's no longer looked at as an asset. But again, we'd have to look at changing the beneficiary to the state if you're a single person, and putting the state as a contingent beneficiary if you're married. Any others?
No, that's it. Oh, wait, one just came in. Okay. Supposing you are older than 70 and RMDs have started, how are qualified funds treated if you want to transfer the remainder to a beneficiary in a trust from a last will and testament? Is this a taxable event?
I'm either I misunderstood the question or the question is a little off. You can't transfer an IRA through a will, if I'm understanding the question right. So if I have a person who is alive, for example, and passes away and doesn't name a beneficiary, then that IRA becomes part of their estate, and then there are very unfavorable tax distribution rules when you don't have a beneficiary. Well, let me take it back. Let me say it differently. Anytime money is taken out of an IRA, it's a taxable event. So hopefully that is a simple answer to what I think is maybe a little bit more complicated question. And whoever asked that question, if I'm not getting it right, when we get to the end, you'll have our phone number and email information. So please feel free to contact me either way, and we can either talk or email about it, so I can understand exactly if I'm not understanding the question. If I don't, I apologize. All right. Any others now?
No, that's it.
Okay. We still have a couple minutes, so if anybody thinks of anything while I've got a couple of two slides to go, please feel free to add it. So we're very big on what we call peace of mind in our office. The whole reason that people implement plans is so that they don't have to worry about these things. So basically it's two easy steps as far as we're concerned. One is to hire an experienced attorney who cares about you and your family, and the second is to implement the plan if you don't have one, or to update a plan if you do have one. So if you've done things even more than a few years ago, I would suggest that it's a good idea to even if you bring it in and have us review it, This way, either we can tell you everything is fine, or explain to you why things maybe need to be either updated or revised. Of course, we'd love to hear from you. We have information on our website, which the website is there, vjrussolaw.com. You can enroll on the website. You can enroll in our e-blasts and blogs. Of course, we're always doing these free educational programs. We actually do one every month, like this, in person and by webinar. There's the contact information that I was just talking about. So there's an 800 number there you can call. You can email us directly at info@vjrussolaw.com. If you call, just ask for me if it's about tonight, or one of the other attorneys who will be able to help you. Some of the legal services, these are the areas that we practice in. So we're very focused on what we do. We don't dabble into other things. This is what we do day in and day out. We've met with thousands and thousands of clients over the years, so we've got a lot of collective experience. And so that's it. I just want to just double check one last time, Mel, questions before I close out?
Nothing.
Nothing. Okay. Thanks for those who did ask questions. And thank you all for participating in the webinar. I guess I should say have a great evening. If you have any additional questions, again, please email them to info@vjrussolaw.com. We have a bunch of great seminars and webinars coming up, so you can check that schedule out on our website. You see there on the screen. And just as a reminder, just to take a minute to fill out the survey after the program ends. And we appreciate your feedback. And again, thanks for listening, and I hope everyone has a great night. Thanks, everyone.